Thank you, and I appreciate Chairman Watson, Chairman Bishop extending me the courtesy and the opportunity to ask questions, though I'm not a member of this committee. If I could just ask a couple of questions about House Bill 433. The language of the bill, which is based directly on your recommendations, as you know, would make some substantive changes to the conduct of the hearing. The use of hearsay evidence would be expanded, and the burden of proof would flip to the person appealing when prima facie of abuse has been established. Can you comment on why you recommended those specific changes?
Certainly.
Your territory, sir.
I want to preface my remarks by making sure everyone appreciates that child abuse happens in there are no socioeconomic boundaries. And the ultimate goal of the process, and this is, we need to make sure we understand the process, and it's not a criminal process. It's distinct and different. We're talking about the County Child Welfare Agency operating as an independent civil agency for investigative purposes. It's not a criminal investigation. Those are distinct and different. Ultimately, the outcome of the child abuse investigation is one of two things, generally. Indicated or unfounded. Unfounded, there's no need to go forward. If it's indicated for child abuse, there's an appeal process, and that's what this bill speaks to. What does that appeal process look like? The task force was very concerned that there's a sense of fairness. I know you're going to hear from other people later today about how we treat those that have been indicated as child abusers. And this bill speaks very well to that and puts in a great deal of safeguards that do not exist. A timely hearing, a timely appeal, notice of appeal, a timely hearing, and what happens there. So to your question, why is there a burden shift, or should there be a burden shift? Currently, the proposed change talks about identifying an injury or harm that the child has sustained that would not otherwise exist but for abuse. That's a pretty high burden. So basically you come in and the agency shows that abuse occurred. We heard hours of testimony from professionals, counties, and law enforcement about how hard it is to go into a home because child abuse usually occurs with somebody they know. Lots of individuals through the course of a day have access to the child. Sometimes you have a child that is nonverbal but has physical injuries that are clearly identifiable as child abuse. Sometimes you have a child that is the victim of years of sexual abuse. Years. Of a stepfather, a case I had in a very prominent neighborhood. Stepfather didn't like the grades was the excuse that the child, this beautiful young girl, brought home. Took her to the basement on a regular basis after getting a report card, stripped her down, duct taped her to the metal pole that supports the basement structure, the floor joists above, and repeatedly raped her because she would bring home a B. The difficulty was, in addition to the sexual acts, there were threats of violence. Threats of violence did not only just harm the girl, but her younger brother and her mother. In the home were other individuals responsible for the welfare of that child, including the stepfather. The goal of child welfare is to protect that child and other children. So in that situation, and this is why I think the legislation and the language you propose is excellent, is we need to identify, one, was this child truly a victim of child abuse? And once we get to that, we narrowly tailor who had the opportunity to do it, who had access on that particular occasion to cause that harm. Otherwise, we can't really protect that child. So what we do is we identify those few people that were responsible for the welfare of that child when that situation occurred, and they can be identified as being the perpetrators of abuse. It doesn't mean that's where it ends. It just means that's the burden that the county would have to prove. At the hearing, those people that would be identified have every opportunity to come in and examine the evidence before the judge, present evidence of their own, and ask questions of one another, and establish that they didn't have the opportunity, or that the other person, maybe stepdad in the example I gave you, was the one actually doing this. At the end of the day, our purpose is to protect that child, and that's the only way we can deal with this legislative change. And this recommendation comes from a great deal of testimony that we took throughout the course of 2012. So I thank you for that language.
I'm sorry.
No, go ahead.
Well, if I could just add, not directly on point, and I was just looking to double check. I don't believe these bills include the particular little bit of language. One of the things we did, and I'm sure that in his introduction, it was indicated that, of course, Mr. Koutalakis' background in this area is as a solicitor to children and youth. We included a recommendation that the children and youth solicitor actually, it's in one of the, okay, I missed it. Oh, terrific. Then man, you got everything. Because this is really modeled, again, on the criminal justice system. Police and prosecutors work together. Police officers may charge particular things that can't be proven because of a lack of understanding of the particular niceties of the crimes code. It's that partnership again, just like the MDIT. This is one of the safeguards. We feel even if you've got either inadequately trained, over-enthusiastic, inexperienced children and youth worker, you're going to have the lawyer who's been selected, and I commend you. I apologize for missing it. That's an important check before you even get to this stage of things. You've got the lawyer who's going to be, in a sense, prosecuting, although, as is pointed out, it's a considerably different process. But you've got somebody right from the get-go who's looking at this and making sure, and I'm delighted that that is in there because I think, from my experience, that's going to be a very important check before you even get to this stage of things.
If I could just follow up with that, and it's just akin to the district attorney signing the information. If I'm a solicitor, my law license is on the line. If I don't have a good faith belief that it warrants the signing of this matter to make it indicated. So it's an extra check and balance well in advance of ever having a case go forward. That's an important note.
My proposal would also clarify that the standard of evidence in these appeal hearings is substantial evidence. In light of a recent Commonwealth Court case requiring clear and convincing evidence, some have suggested that this higher standard may be required, or at least more appropriate for these hearings. Can you specifically comment on that and specifically offer any thoughts you may have on the standard of evidence used in these hearings?
I'm aware of the case. It came out, I believe, in July of last year. Quite frankly, ethically, I guess I'm not supposed to hold the judiciary branch in any disregard, and I don't mean to do so. I just frankly think it usurped your role, that case. I think it was a legislative action by the bench in the Commonwealth Court, quite frankly. It set on its ear decades of case law that said the standard was substantial. This will undoubtedly put children at risk. These cases are extremely hard to prove. A homicide case is often a lot easier to prove than prosecuting a case where a young child has been victimized of sexual abuse in particular. They're very hard to convince a family to bring their child forth and be subject to cross-examination even, to the interview. These cases are hard to prove. So I think that case is an anomaly. I think the case upends decades of case law. I think, frankly, the Commonwealth Court took your role away from you. And the burden of proof is a fair one. It's not unreasonable. It's well-based. And it's rationally based, which I think is where we need to be to make. And again, we heard testimony on this issue a great deal and would ask you to support that change, clarification anyway.